So this panel today is looking at the idea of legal education and professional training in international law. And we've chosen to have the focus here very much on the legal education aspect and the channels through which people in different states come to study and then practice in international law. And we have decided, contrary to typical ASIL approaches, to not do this as a regular panel, but to actually do this as a conversation. So I'm going to start off by telling you just a little bit about some of the general patterns that we see about student flows. And then I'm going to start the conversation going with Natalie about what this might mean in international law. So let me sort of start by just giving you a bit of a macro picture about what we see about legal education, which is legal education used to primarily be a national endeavour. And it was something where, because law was highly dependent on your particular national jurisdiction, people typically studied law in their home jurisdiction. There was some movement at graduate levels, but at a relatively smaller amount. What we're increasingly seeing now is that people are being educated for law in different states, but there is an increasing number of students who are crossing borders to study law. Most of this is happening at the LLM level, some at the PhD level, and we're also going to hear from Carol Silva that some of this is also happening at the first degree level. And we've got some questions which we're going to discuss on this panel about what those flows look like when you're in different states, in the core or in the periphery, and what sort of competition is going on. But also the question about how this may end up affecting international law as a field. So before I turn over to our first speaker, let me just put forward sort of two general macro ideas about what happens with student flows, and then we'll ask how do they apply in international law specifically. So the two general macro points to make about cross-border flows of students is, first of all, that it's very asymmetrical. What you find is that students typically, if they cross borders to study law, they go from the periphery towards the core, they go from the non-Western towards the Western, and that what you then find is that many of them end up returning home afterwards in order to practice. And so you get, in the end, you get two different asymmetries. The first is that students move from the outer towards the core, but then legal ideas, legal materials, legal sources often move back with them as they go. And so we've got these two different asymmetries of students moving in and ideas and materials often moving out. But we also don't just have one core periphery dynamic. We have different core periphery dynamics around particular countries based on language, legal systems, and history. And so if you look at student flows, there's very clearly an Anglophone core, a Francophone core, a Russophone core, etc. They're not all the same height. There is many more students now from many non-English speaking backgrounds, for example, going to study in English speaking countries, so the Anglophone core would be higher, but there are very distinct patterns of students going from certain countries to other countries. So if you look, for example, at outbound flows from Nigeria, Anglophone, it's very strongly to the US and UK. If you look almost next door at Mauritania, very, very strongly towards France and towards Paris. And so these are the sort of macro dynamics that shape movement for students studying abroad. And I think I want to open this conversation up initially by turning to Natalie Reid, who is a partner at Debevoise and Plimpton in New York, to ask, how does this play out in the international field? Are these the dynamics we see, or is it actually more specific even in the international law field?
Thank you very much, Anthea. I think we see this play out in the way that you would expect from the phenomena that you describe, both at a general level and at a more specific level within particular practice areas. So if we pause for a minute, both in this panel, in your book, and I think many times at the Society's meetings, we will often hear invoked Oscar Schachter's Invisible College. I know in your book you would also refer to the Divisible College and about what some of the phenomena we see in legal education and legal training mean for conceptions of international international law. If we think, for example, about where the members of this invisible college reside, not just geographically, but institutionally, we still, of course, have a lot of international lawyers who are in national governments, who are embedded in national governments. But we know that we have international lawyers of various kinds in private practice in firms and in international institutions and multilateral institutions. And it is in those latter two categories that, for example, my own practice has been focused. And I think what we see there is something that both your and Bryant's scholarship has focused on, which explains a little bit of the why of the asymmetrical movement that you're talking about. For lawyers, for students, young lawyers and practitioners who want to practice at the top of the field, who want to be hired by the elite firms who do some of the most interesting work, who want to work at the tribunals and courts in which some of the most critical and challenging questions of international law are resolved, it is critical to be credentialed in a way that you have access to those jobs in the first place. What that means is that there are relatively narrow paths to the field that can in some ways both expand and sort of reinforce a lot of the dynamics that you're talking about. It matters when you come from Jamaica, like I do, where your first and second degrees are. It matters for the opportunities that open up after that. It matters for the jobs that you are eligible for. And the initial jobs that you're eligible for will then define the responsibilities that you have, will then define the profile that you build, will then have an impact on your reputation in the field, and will, you see this at the individual level, and you see it at an aggregate level. So for example, to get a little bit more concrete, I spent, if you think about it, between 2.5 years and 3 years in the international tribunals, international criminal tribunals. There were not a lot of Caribbean practitioners there, but the ones of us who were there, almost all of us had at least one degree from a US or UK institution, and not just any US or UK institution, but of course the ones that are viewed as being the top and elite. And if you asked us the question, many of us had done that as a conscious choice in order to increase our eligibility precisely for those jobs.
And what impact do you actually think it then has on the way in which the people practice international law in these institutions?
I think it has conscious and unconscious impacts. The unconscious impacts, of course, are a lot of the things that you cover in your book, which is the way in which we are taught international law. There's relatively little question about, sort of, is this a westernized view of international law? Does this reflect sort of dominant views of what the fundamental principles are, how they interrelate, and how they can be resolved in any particular situation? You are taught this is how public international law works. You are taught sort of a hierarchy of sources, whether or not people acknowledge as a hierarchy, and you bring that with you as part of the toolbox, your skill set that you apply when you get to whether it is a firm or an international institution. The conscious ways that it will impact, and again, as many of us know, when you are practicing in a particular field, there is, I think, over time, a homogenizing effect of practicing in that field. Part of the credentialing process is to have that degree that says, that you are qualified and that you're eligible. Once you get there, in order to be taken seriously, you have to speak the language. You have to speak the vernacular. And I think many of us will consciously do that in order to create confidence in those with whom we interact and those who will ultimately be the consumers of our work, that we know what we're talking about and that we're part of the group. So this is, again, reinforcing some insider-outsider dynamics that I know we'll talk about more.
So I thank you very much for that. So I see Lucy actually nodding in agreement. So I was going to cut to somebody first, but let me come to you actually, because you've seen this in a number of locations and you've now gone into teaching after a long time in international practice, both for the government and for firms in the West. But you're now in Singapore observing these dynamics. So how does it look from there?
Thank you, Anthea. Well, Natalie and I come from similar backgrounds. So I've worked in private practice at Freshfields with lawyers from many countries, both civil law, Francophone lawyers and Anglophone, who have this kind of training that Natalie has described. And now that I've gone into NUS, where I'm directing the Center for International Law and teaching on the law faculty there, I I will say for this discussion and this group, the thing that intrigues me most, and I think all of you here should be aware of, is that in Asia right now, there is an outflow of students from Asia, an aggressive funded outflow of students from Asia, especially China, to our schools in the West, whether they're in France and Germany or the US, UK, Australia, New Zealand. I have one statistic for you, which is from the 2017 Open Doors report of the Institute of International Education, which says that 6 out of the top 10 sends of international students to the US come from Asia, with Chinese students accounting for 33% of those students. This is not just law students. And the thing that interests me is China is particularly investing in training their students to come back to China in international economic law and law of the sea, which boils down in plain language to the fact that China is determined to fund and educate its students in Western Westphalian international law as we know it and as we are second guessing to use on the global plane, either for us or against us, in disputes such as the South China Sea. And there is no equivalent of the United States, my jurisdiction, sending and investing either in these fields, by the way, or in sending students abroad. So what I see in Singapore is, while Tony Anghie, known to many of you, one of the pioneers in the TWAIL, third world approaches to international law movement, Tony and I trying to focus our students on climate change, environment as a part of human rights law, and on cybersecurity as the areas where they should be learning international law, we get massive pushback. The LLBs from Singapore who want to practice in Singapore want to know basic international law, you know, UN, ICJ statute, the basics of international law. They're not open to learning a different approach. And the foreign students, the same thing. They want to know what Natalie knows. You know, they want to know that kind of law. And I think it's unfortunate because we're going into several decades where, as we have learned and as we're teaching, international law is not as relevant or important as it should be. So I'll stop with those observations right now. But Asia is here in international law more than we are here in international law.
So just to very much echo that, so one of the things I've seen, certainly in my research, is a very conscious push not just to internationalise in the education, but also to focus on certain areas of international law. And so one way that I evidence that in the book is to look at funding. And I look at, for example, the Chinese government actually puts out every year recommended topics of research. Including recommended topics of research in international law. And so I looked at what were they recommending. And if you sort of plot it against the various subjects of international law, what you see is international economic law, law of the sea, particularly post-2009, international environmental law, and then kind of not really focused on many other subjects at all. And not only is it a very, very sort of strong orientation towards certain fields of international law, but to pick up on your point, it's such a stark contrast with the US, where it's very, very hard to find law of the sea scholars at many or almost any of the US universities, or professors of international law of the sea, or actually in international economic law as well. So there are some in international economic law, some in trade, fewer in investment, but actually we're still relying a lot just on having practitioners teach those. And so not only is there a different focus in the different countries, but the disconnect in what we're considering to be important as a field, I think, is stark. Just before I turn over to ask about what happens in the US, though, I guess my question is, what's the consequence of that?
Oh, that's a good question. I think the consequence will be, in one sense, a more level playing field of education amongst Asians and, using your definition, Western lawyers, but not necessarily the most forward-looking playing field in terms of the challenges facing international law. And we'll come back other challenges of teaching international law in Asia. Asia is a very big place, and there are a lot of differences. But one of the things I've always found frustrating in my work with the society and practicing, like Natalie, and endless discussions we have, is never being able to convince law school faculties, particularly in the United States, not those who are in this room, but general law school professors, or in Singapore, that international law should not be over here and everything else over here, that contracts should have a part of international law, torts has a part of international law, IBT, of course, procedure, criminal law. International law should be integrated, and so long as it's not tested, I think, by, for licensing in the US or by the ABA, it's not going to be integrated into syllabi. And I like to think that in Asia, and as Andrea points out, for better or worse, a lot of the faculty members are educated in Western law schools. If they, maybe there's a chance that they will be able to take, or we will be able to take that approach to the increased interest and the many more students who want to study, be ready for global law, international law writ large, by being able to accomplish what we can't do here with new student bodies.
That's really...
It's probably Pollyannish, but I said it.
So there's obviously been, in both of these sets of remarks, a real discussion about how students come from the periphery and come towards certain core states. And so we have highly internationalized student bodies when we come to certain core states like the United States. And this is where I'm going to actually turn to Carol, because Carol's done some fantastic work about international students here in America. And I think the question I would sort of start you off with is, it looks wonderfully internationalized. Is it?
Thank you.
Yes.
Okay. Thanks for including me on this panel, which is fascinating. So in some sense, it is wonderfully internationalized. Law schools are welcoming increasing numbers of international law graduates. More law schools have programs specifically designed for international law graduates today than they did years ago. The numbers just keep going up. So in some sense, it looks like law schools have the welcome mat open out and are actively looking for international students. But the program that most international students have gone into in U.S. law schools, as you know, is the LLM. And the LLM is somewhat segregated. Students are only there for a year. They can't, as a practical matter, get involved in every single kind of course. Schools actively limit them. They purposefully limit them, restrict them different ways. So some schools restrict them from participating in first-year courses. Some schools limit them from participating in clinics. Some schools limit them with regard to law review and moot court. So the places that they might meet American students are limited and restricted, and that has a huge impact on them. On the other hand, the students who come into LLM programs are in a very international population in the LLM, and so they get the benefit of that, even if they don't get the benefit of meeting and really getting to know American students. So several years ago, I did some research just to see what do American students know about international graduate students who are in the building, and I asked a couple of questions through a survey called the Law School Survey of Student Engagement. It turns out that the most common place for American students to interact with international graduate students, so LLM students, was in the classroom. But the comments indicated what they didn't want to hear was, in my country, we do it this way. They were in a U.S. law school, U.S. law classroom, and that was just going to frustrate them. So if you think about the kind of interaction that might take place in a law school classroom between international law graduates in an LLM program and JD students, it's rather limited. Occasionally I ask my students if they know each other in a class of 50 students, and they always say no, so I ask them to get up and introduce themselves to someone they don't know. So that's a start, right? Where are you from? And there are lots of other ways to go about this, but they're just sort of basic human nature approaches that we tend not to take in law school. So as you mentioned, more and more students are actually, international students are actually enrolling in the US JD program too. So they're infiltrating that core part of US law school, and I'm interested to know whether that makes a difference and kind of punctures the identity of the law schools. And so I've done some research on international JD populations. Here it isn't just students from the periphery going to the core. Actually about a quarter of the JDs are from Canada. So the dynamics are slightly different, but 60% of all international JD students are from Canada, China, and South Korea. So it's not that international of a group. And the Canadians can kind of slide in and assimilate, and they do. They feel a little bit put out when they have to deal with visa issues or special credit issues, for example. When they want to work, they have to actually be enrolled in a class. But other than that, they don't have too much trouble. But the other students do have just as much of a hard time integrating into the social and cultural fabric of the law schools as international LLMs. And at the same time, they're not a bridge to the LLMs. They want to push away from the LLMs. They identify the LLM program as being entirely international. They don't want to be seen as only international, and so they distance themselves as well. And their experience in law school classrooms is traumatic in many cases. So I have a number of quotes, and I'll just read you one. And this is a Chinese JD student who ended up graduating from her law school. She had gone to college in the United States, and she said, when there's a class discussion, and when I'm paired with other people, and when I talk, people don't have eye contact with me. I wonder why. And then I tend not to like those classes with class discussions. So there's actually a lot of thought that international JD students put into course selection. And what they say is, for several reasons, they're more interested in business courses and transactional courses than anything else. So first, they don't want to be in con law where they know they're going to constantly have to play catch up because they don't know American society and they can't possibly catch up. And second, they're worried about their ability to stay in the US because of visa restrictions, and so they want to hedge their bets. Their perception is that litigation is tough to do, both in the US and also to take with you, and that a transactional practice will set them up in a more realistic fashion for eventually either returning home or going to London or in any event leaving the United States if they have to leave the United States. So what it looks like at the large level, at the general level, is a huge inflow of international students from all over the world. And what it's experienced at a micro level is this huge inflow, but segmentation within the population of US law schools, both reinforced by policies of law schools, sometimes simply policies that have failed to adapt to this new population of students, and also the social interaction that really is human nature. It's not something uniquely American. It happens in every country where there's an inflow of international students.
So what you're describing, I have witnessed as both a student who has studied in multiple countries and also someone who has taught in multiple countries, which is these often very divided populations. So I look at my LLM students, and I, as an LLM student, came out with a fantastic network of foreign international friends and actually no American friends. The communities were very, very different. But it actually makes me think very strongly about the role for the American students who are, as you also said, Lucy, they're very, very unlikely to travel abroad to study. So they don't have that internationalizing experience of studying in America law and then studying law elsewhere. They only study law here. And then you think, well, they'll get all of the international influx from their classes, but in fact what you end up finding is that even though macro it looks diverse, in a micro way there's much less interpenetration than you would think. Now, I want to pan back now to ask Bryant, who's done studies on these dynamics globally, because it's not just now in the US that we're sort of pitching for these global law schools in the UK, even though they're still dominant. We're starting to see this develop around the world. So can you tell us a little bit about the sort of what's happening worldwide on these issues?
I can tell a very simplified story in a sense, but I'll start with, and I think it's worth reminding that there is this intense competition globally for the LLM students, also for the LLB students, growing as well. And the competition it's about partly competing empires, but it's also about money. And there's a lot of competition to get those Chinese dollars coming into the US. So that's one part. But the second thing I want to make about this kind of competition, which is leading to mimicry in the sense that you have US-style law schools being created around the world, or reforms in various law schools, Japan, Korea, China, elsewhere, that are more on the US style. So the flow doesn't need just to be the flow of students back and forth, because you have much more US-style schools being set up, and there's a lot that can be said about that, but I'll just sort of drop that in for the moment. Second thing is that, in a way, this is being described as new, in the sense that, and the US is ahead, but we should be reminded that it's not that new. This is what empires did. It wasn't a huge flow of people, but it was a flow of elites to get their studies in London or in Cambridge. And it's interesting when you see the studies of what they did when they were there, is they were treated completely marginally by the British, and they even formed some of their movements for independence among themselves, like with the Malaysians meeting each other and getting to know each other in London rather than elsewhere. So what's different is that in the 1980s, in particular, the US kind of stepped into shoes as a kind of anti-imperial empire, but occupied the same kind of hegemonic relationship that there was before, core and periphery relationship, but it was different. It was more US, and it was more open, less than the traditional colonial relationships, and usurped those old colonial relationships to a great extent. So you got to the point where, in terms of international law, you could say that the dominant strain of international law was produced or anchored at Harvard, but at the same time, in the 1980s, 1990s, and early 21st century, the counter-hegemonic international law, TWAIL, is also produced in large part at Harvard or out of the Harvard relationships. So it's a complex form of hegemony that takes place. And so then the question is, out of all this, kind of the sociological question is, with this mobility going back and forth, with this kind of core and periphery relationship, with this kind of convergence in the sense that people from around the world speak a similar international law language, is this more legitimacy for international law, or is it a more one-sided international law? All of those have more legitimacy because there's more participants, there's more people who know how to play the game. But at the same time, there's more hegemony in the sense that you learn who the hierarchies are, you learn you're supposed to defer to this professor or that professor, and you're going to be taken more seriously if you learn how to play those hierarchies. So it's both things at a certain extent. And it's a question in two senses. One, which really relates to your book, Anthea, is this question of the place of international law. That is, does international law count? How much do you invest in international law? Does international law, should it be, play the major role in determining some of these kinds of disputes like the South China Seas? Or is international law itself something relatively marginal? And you make the contrast that the Russians don't really invest so much in international law. So the question is, if the Chinese are investing a lot in international law, that props up the place of international law, which is good for the US overall, even though it will change the content of international law, open it up, perhaps, make it more legitimate. Maybe if it makes it too legitimate, the US will turn on it like it does to the WTO.
That's what I was going to say, it is the WTO story.
But both of those things are happening. So I want to just point out that the hierarchies haven't gone away, even when you legitimate it, make it more equal, open up to different voices when they come back and forth.
Yeah. So I want to sort of echo one thing you said about how often the counter-hegemonic forces are also done in the core with these student flows. So one thing that really struck me when I was doing this research was actually the role of India in this process, because I thought, you know, India deeply connected with third world approaches to international law. I would find a lot of that at the Indian law schools. No, actually, I really didn't. The first thing I found was that there was no Indian textbook of international law, that the only international law textbooks they were using were British textbooks. And if you use the textbook of your former colonial master to teach you international law, you learn absolutely nothing about Indian international law. Even though India has a very interesting and active Supreme Court, India has some very, very interesting executive practice, India has a very different approach on a number of core issues. That's great, but actually you won't know that with the way that you study international law at many of these law schools. And in fact, TWAIL just wasn't even really located in the law schools. There were the connections through to Harvard, but also when it was in, it wasn't actually with the law schools. And I think you probably see both of these phenomena happening in Asia, the role of what the materials are and where the resistance is and how it develops.
I definitely do, and I'll mention Tony Angie, who's very open in saying he could never have helped develop TWAIL if he were in his native Sri Lanka. It'd be impossible. He had to be in Cambridge at Harvard to do that. Again, Anthea has covered this in her book, but it won't surprise you that in Asia and in Southeast Asia, most of the textbooks are Western textbooks and they are in English. We're doing we at NUS are doing a conference on teaching international law in Asia this coming June, and we're doing a survey in preparation for that. It's a bottom-up type approach, and we have confirmed, hasn't changed much since there was a conference like this 17 years ago, that only Indonesia and the Philippines have introductory international law books in their own language. So we've got students learning international law either in their own language, only in a few places, and otherwise in English as written by Westerners, which is, of course, going to affect the openness and the sophistication of the real breadth of international law in Asia. And in many of the schools, there are not, in Southeast Asia, there aren't even basic library facilities. I know Jane Willems is here. In Cambodia and Laos, they don't even have the databases. They don't have internet access to JSTOR or Westlaw at all. Bhutan, I think, has one foreign law graduate and I think 4 books in the library in their new law school. And the other end, we have Singapore and Vietnam, which is quite advanced, and China. So there's a lot of development and equalization that will have to come in the teaching of international law. And we're looking at NUS at the opportunity to have discussions with leaders from all the law schools, from all the ASEAN and Asia-Pac countries about what's needed and how to teach it. It's a great need for curricula to use, but that creates this moral dilemma for me, because when I was president of the American Society, Jose and I wrote a 1-hour curriculum on basic international law to give at, we gave it in New York at the Bar Association, because I realized in my law firm that a lot of the associates in even a top firm like Freshfields doing corporate law, transactional law with cross-border transactions had no idea, had never taken international law, of course, and didn't know the first thing about it. So they would come to me kind of embarrassed and say, exactly what is customary international law? You know, or what do you mean by private versus public international law? So we did this 1-hour and 3-hour basics of the sources of international law. Jose did the foreign relations side, the US approach to international law, and I did the basics. And I was thinking of pulling that out again to use, but I'm kind of embarrassed by it, because it's so Western and so old-fashioned, if you will. So I haven't solved that dilemma yet. But what was the question?
The textbooks and materials, but also
yes.
how we actually develop things like third world approaches,
Yeah.
but in an organic way, so we actually understand what's happening.
So I've talked, textbooks resources are very limited. The other thing is that we find, and I can't speak for the US, but a lot of the professors in the law schools in Asia who teach international law have been doing it for about 100 years. They haven't changed their outlines. They don't want to change. They certainly don't understand how to do the kind of research that will get them into the leading peer-reviewed law journals. And yet there are a lot of international law professors, and I'm sure others in Asia, are facing the pressure, the younger ones, to get tenure, to move ahead, to be able to publish at the level, if not the American Journal, but certainly peer-reviewed journals, and they don't know how, and they don't have the resources, and they've been taught by people who don't know how to do that kind of research, which leads to the sort of TWAIL approach too, which is, why do we put so much value on that type of research and that type of global Western-dominated publication for achievement in academics in international law outside of the small core area. So lots of challenges.
And it actually relates to something that a sociologist I saw who wrote about, because this is not just in international law, this is also whenever you're creating international fields and you're dealing with hierarchies of universities across states, but also hierarchies of journals. And she said that one of the very first things you've got to think about is, which language do I publish in? Do I publish in my local language and speak to a local community, or do I publish in English, was the choice that this person was facing. And she had a really nice phrase for it. She said, my choice is, do I publish locally and perish globally, or do I publish globally and perish locally? And this real sense, I think, of either servicing an external audience or an internal audience, but actually many people making a choice to go in one direction or another. But to your point on hierarchy, the ones that were sort of hierarchically situated at the more elite schools tended to focus out and not talk with their home communities, and the ones at the less elite tended to talk to their home crowd, and so it creates a stratification. On that, actually, can I pass over to you, Bryant, because you've done work on sort of global professions, global scholarship. Is there any global scholarship on these things, or how would you describe the situation?
You mean global scholarship on this phenomenon? Or
no. The phenomenon, is there a phenomenon of global scholarship?
There certainly is a phenomenon of talk and contestation around something called global scholarship. And it's not just getting published in the US journals or British journals. It's that if you're in most of the countries of the world, if you study your own country and you write a brilliant interdisciplinary cutting-edge article about your own country, nobody cares about it. Right. So it's doubly hard to get published in the international journals unless you can play the kind of double edge, which some do, which is they say corporate governance in the US, is the gold standard, but you need to take into account the situation in Brazil because things are a little bit different, and then you can sell Brazil, but you're also at the same time ensuring the dominance of the paradigm that comes out of the US, because that's what you need to play. So you certainly see this exactly, but it's also, it's fought. It's fought in Brazil, it's fought in India, it's fought in many places, is the question, who should be a professor, or who should speak the language of the law? And professors are very marginal in India in any event, but part of using international level research is a way to try to topple the bar. The bar is very conservative, very reactionary, and using this sort of international currency, new cutting edge, empirical and all that is a way to try to, take them on. And you see that very much. You see it in Korea, in the legal education in Korea. But yes, this is being fought out in many different places. And part of what happens with this new generation of law schools and legal reforms is they enter into that debate. But so far you cannot find a school where they have succeeded, outside of the U.S. in playing successfully at the U.S. level. And the last thing to say is that if this goes to Harvard as well, American students don't go abroad, but by definition, everything that happens in the U.S. is of international importance, so they don't need to.
Yes.
And if I could jump in here with perhaps the perspective from practice, and I should say, to the extent that it bears on the weight you give to my words, I consciously chose to go to Harvard over other schools for a number of reasons. Some of the issues and sort of themes that we're touching on about the interrelationship between language and audience and sources plays out in practice as well, again, in very conscious ways. So Lucy, you touched on, sort of foreign relations law as almost sort of like the US conception of law. I think about it from my perspective and my practice as an advocate, right? When you're an advocate, you have to think of who your audience is. So when we are, as we do quite a lot in our practice, when we are writing amicus briefs for US Courts of Appeals or the US Supreme Court on questions of international law and the interrelationship of international law in domestic courts, you have to cite US sources. You have to cite US cases, even if they may not be the best or perhaps always accurate accounts of those particular doctrines of international law. We do, out of reasons of, I think, doctrinal integrity and professional responsibility, also cite international sources. But I will be frank, the balance between the US sources and the international sources that we cite will reflect who we are trying to reach as our audience. And that will sometimes take into account the fact that the court may not be our only audience. So if the amicus brief, for example, may be directed to a court, but intentionally has a broader global audience because of the goals of that particular client, then we may very well cite a range of international law sources that will be more familiar to those of us who practice outside of US courts. The same thing, frankly, you will find in international courts and tribunals. You cite the sources that you know that those judges will recognize, that will resonate with them. There are times, and perhaps if you think again from my own practice, early in the history of the international criminal tribunals, there was quite a lot of criticism, I think justified criticism, about the sources that those tribunals looked to determine the content of customary international law, because they tended to map onto whoever had done the research and had done the initial draft of that judgment or that decision, and the jurisdictions from which they came and where they were looking. One of the interesting things that we see, whether it is in domestic courts, but certainly in international courts as well, is we still see the the effect and the implications of linguistic dominance. That we, even with the range of whether it's domestic sources or international law sources, many of them, if not most of them, will still be English. And when we reach outside of English for other sources, then we apply French sources, and we feel very good for ourselves because we have brought sort of bilingual depth and support for our arguments without questioning and without wondering whether you had reached, if you reach outside those two language bodies, you would find perhaps conflicting sources, that you would have a richer and more accurate discussion of whatever that particular point would be.
And just to reinforce your point about the sort of educational and jurisdictional backgrounds, the studies that suggest before the international tribunals that they refer to very limited sources, largely English-speaking, largely Anglo-American, with a smattering of French, also maps onto where you find these people have studied, both the judges and their clerks. And so there is some study, I don't have the statistics right with me, but about the percentage of the international judiciary that had done their law degree, their first or second law degree, at just a handful of universities on the east coast of America, in the UK, and in Paris. And so it's a sort of a funneling process through which we sort of learn the lingua franca of international law. Looks like
you have something. Can I say a word on that too?
You may.
Okay. Just that if you went back to early in the 20th century, of course, all the authorities cited even in US courts would be international ones. They would be the French, they would be the Germans, they would be the British, they would be the Italians. And so the change is that it's not because they were educated in these countries, they are educated in these countries because of the power of these countries to speak the discourse and define the contours of the law.
Which goes to your point, I think, as well, Lucy, which is how do we stay relevant in a new world order where we don't have the same power that we had before. But it's a complicated relationship, right? So the West is declining in importance economically and geopolitically, and yet it still has incredible dominance in sort of international thought and international education. And so we see the rise of Asia generally economically, but we also see them very much coming to do the studies in the West, and yet also, some of them at least, putting a lot of money into trying to build up the study in their home country, particularly China and Singapore. So it's actually a very complicated dynamic. I don't know what you want to say on that one.
Well, I'll just say that I think it's purposeful, and China and probably other countries are adding intellectual capital to their economic capital. But I didn't want to say anything just then. I wanted to ask Carol, because I'm particularly now that I am in the education world full-time, or almost full-time, the segregation that you talk about is really a troubling thing to see, and I spend more time than I did at Freshfields, where we had quite an integrated practice with lots of people from different countries and trainings, but we're all working on the same project, so there was natural integration. What can be done? I mean, what can law, there are a lot of law professors here, what can be done? Who has the resources? Is it money? Is it time? What can we do about this?
I think it's very...
If we need to do anything.
Yep, so I do think we need to do something. And to facilitate people actually speaking to each other, getting to know one another. I mean, frankly, that will help the American students. It will enrich our classrooms, and it will certainly give the international students what they're coming here for, in part of their reason for coming here. But what can be done is, interestingly, unexplored, and probably is not all that different from thinking about integration, interaction generally with any population. And I think in that score, also relatively unexplored. So intentionally designing ways for students to interact where the power is not what you would expect. So if the power is always with the US student because they're working in English and on something with regard to US law, you're not going to get very far. But if the power then shifts to the international student because we require their language ability or their knowledge of their home country or something that they have, then maybe things will start to even out. So, I mean, I do all kinds of things to experiment, but I can't tell you that they work.
I actually have a practical example of this. So when I was in law school, I participated in, as a contestant, the Jessup International Law Moot Court Competition, and the finals are today, for those who are interested. And at the time that I was at law school, for a number of reasons, we had no faculty sponsor, so it was entirely student-run. And for us, the LLM and SJD students were our coaches. And they were not sort of the formal coaches, but certainly for our mock panels. And there was a richness to that interaction, and sort of coming back to that imbalance. A number of them had gone through the Jessup before. They certainly knew more about public international law than I did as a first-year law student, and they put me through my paces. There are relationships, frankly, that I developed through those mock sessions that I still maintain today. You know, sort of people that I run into on sort of the floor of the ASEAN annual meeting. That I would not otherwise have, because you're absolutely right. When we're in the JD classes, and it turned into, you know, we didn't have memes in those days, but it would have been a meme, sort of, in my country, and then all the JD students stop listening. That's right. Whereas if I'm standing in front of you, and it doesn't, you know, it doesn't necessarily need to be limited to the Jessup. It could be the VIS, it could be other moot court competitions, and I know that Lucy has some thoughts about that as well, where there is a premium placed on the knowledge and experience of the LLM or the SJD student over the JD student. Right.
I expect we probably all have stories about the Jessup. I'll turn to you two in a second with stories about the Jessup, but let me give you just a handful of stories of what I encountered through this research about the Jessup. So the first one was in the Russian context. It's only been in about the last 10 years they've started doing the Jessup moot. And what my Russian colleagues tell me about this is that they first learn international law in Russia using Russian sources and Russian textbooks, and they think they know international law. And then they go and do the Jessup, and they have to ditch all of those Russian sources and all of those Russian textbooks and learn a much more anglicized and often UK and American approach to international law. And they say that that sort of they learn totally different sources, they plead in a totally different way, so they learn these two completely different international laws. And when they come back, they find there's a massive disconnect so that they can talk to their international friends in this new international language, but they actually can't talk to the group I describe as the old guard, because they're actually speaking in completely different languages with completely different sources, and there's no connection between them. And actually most of them are now not going into the academy, that they haven't yet penetrated that. I saw that happening very clearly in Russia. In China, I saw it, again, in a much more strategic way. So I came across quite late in the process a manual by one of the Chinese societies of international law, which was a how-to do Jessup mooting on the international stage. And it was a wonderful example of a document about showing you the socialization process. So they said nothing about Chinese sources. So everybody would have done their first international law subject using Chinese sources and Chinese textbooks. But that all just goes out the window. Instead, they say, look, what you need to do Jessup, other than obviously speak in English, that was just taken as assumed, is you need to get a UK international law textbook. We recommend Brownlee, Shaw, and Evans. You need to cite cases from the US Supreme Court, the UK Supreme Court, Canada, and Australia. And you need to draw on articles from the American Journal of International Law and the European Journal of International Law. And as a socialization process about what it is you need to do the lingua franca, Natalie, that you first talked about, it was wild, right? It was so spot on. And yet, what it does to these people when they come back is that they don't know how to connect these two different communities. Before I pass to Lucy to talk about that and what she's seen on that, I think the one other example I had from the Jessup, which I found quite interesting, was it's meant to be obviously pleading before the International Court of Justice. So one of my French colleagues who actually does do pleadings before the International Court of Justice was teaching here in America, and so he was asked to judge the Jessup. And he was completely horrified. He was like, this is like an American trial court. Everyone keeps interrupting. He's like, this is not what the ICJ is like at all. And he was like, this is not international. This is American common law pretending to be international. And so I think there are so many stories about the Jessup and what it does in this process. And I didn't even know when I started this that there is an equivalent to the Jessup, but in French, the Rousseau moot. And it calls itself the French Jessup, but of course we don't call ourselves the English Rousseau. You know, there are really interesting dynamics on there. So what do you see with the moot courts in Asia? Because they're becoming incredibly popular now.
Yes, I can't add too much to what you said, but compared to 10 years ago, there's much more participation from the ASEAN countries in particular in the main moots, and only Brunei actually does not. Well, Brunei, Laos, and Myanmar have not been participating in the Jessup, and I think that has more to do with funding than it does with desire. And all the ASEAN countries except Brunei participate in one of the most popular moots from the Asian perspective, which is the International Humanitarian Law moots. I don't know how many of you would be familiar with that. I did some practice rounds this year. It's much more realistic than the Jessup because they get problems with a half an hour to prepare, to sit down like with a commander to discuss a plan, or with the ICRC to discuss an issue. Very different testing and use of international humanitarian law sources than we see with the Jessup. What I think about the moots is I think sociologically they're absolutely fantastic. To have the Jessup Moody's and the Vis Moody's get to know each other, people from so many countries, and as Natalie says, they'll stay close. They'll develop a network, but I'm troubled, and I have to recognize it's quite a skewed perspective, a narrow perspective of what is international law. In Singapore, it's like the national jousting competition. It's a sport, and people talk about their Jessup success 25 years ago as still a measure of their worth. So I worry a little bit. I worry a little bit about it.
So, Bryant, on moots.
Well, just one thing is that it's become part of the international elite credential. You know, so it's a recognition. So they pick up, and that's your ticket to come to the U.S. or to Oxford is to win the Jessup or do something like that, as well. But I was going to say there's at least the hypothetical possibility. You know, it used to be that Japanese students of economics would come to the U.S. and get PhDs in American-style economics, And it was just to inoculate them. It was just for them to know, what the dominant discourse was so that they could preserve their state and their relationships with business. So there's at least hypothetically that possible that people don't always buy into the dominant one. But then the point I wanted to make about what you said in Jessup is when you refer to your home country, I wonder, and this is a question for Carol in a way, if you have lots of Chinese American, lots of Chinese, Taiwanese, you can say in China, and people will say, oh yeah, China is interesting, because if the dominance in the classroom starts to change a little bit, there becomes at least interest to the places that are considered to count by those in the room. So maybe there's some slow, that doesn't mean that anyone cares about the Philippines, but it can change a little bit.
Yep, so it could. My experience is that it's not changing yet, and so it takes some specific direction. So I know I've talked to you about, in the past, I've had this idea of, thank you, I have a really loud voice, so this is going to go out. I've thought, if in a class where there are a substantial number of international law graduates, so international LLMs typically, although some now are in JD programs, wouldn't it be fun to capitalize on that and have them talk about various topics in a way that I direct, so that I sanction it and say, we're going to do this now. I don't do it as part of a short number of hours in a regular course, but I do add a session, and in the future I'm going to teach a semester's worth of that. So the students will select the topics based on their knowledge of US law and of the field, and I teach corporate law, and talk about various discrete topics. So for example, we had a beautiful discussion by a Japanese student about shareholder proposals. In the US, you can only do a very limited number of shareholder proposals in any one annual year. In Japan, you can do an unlimited number of shareholder proposals, and he gave this great example about a particular shareholder who made proposals about Western toilets. And of course, most of the students in the class, this was voluntary for students to come, but there were quite a lot of American students there. They didn't know what that meant. And he tried to physically demonstrate what that meant. So it was a really wonderful learning moment. And another student from China talked about state-owned enterprises, and she went on for 5 minutes, and the first question from an American student was, what is a state-owned enterprise? They had no idea what it was, much less what the nuance was that she was talking about. So we'll see where it goes, but my idea is that every topic that has a good number of international law graduates in the class could have this extra class that some students sign up for, enroll in, get credit for, and it's essentially taught and directed by the students in the class. So I'm not quite sure how it will go. It's going to be pretty loose, I think, and it's an experiment, but we'll see how it goes.
So I just want to pick up on this idea, because I think there's a more general pattern that at least I'm observing, and I sort of observed it first in international law, but I'm now observing it in many other fields as well. And this is a sort of a dynamic that I'd call the hegemony insularity or hegemony ignorance dynamic, which is if you have a core-periphery relationship, if you start in the core, you've often got very little incentive to travel out to the periphery, but you have maximum ability to diffuse your ideas out to the periphery. So the core is very influential, but the core itself is often, whilst also being hegemonic, rather ignorant, because they don't take on nearly as many sort of ideas from outside. And you see this obviously in some of the sort of core periphery dynamics in education. You also see it, for example, in core periphery dynamics in the social sciences. So you find economics, as the queen of the social sciences, is very able to sort of diffuse in a more hegemonic way its ideas out to other social sciences, but it itself learns nothing about the other social sciences, doesn't value interdisciplinarity, and doesn't cite from them. And I guess one of the things that sort of troubles me about this dynamic is what happens as we have changing geopolitical and economic power. So it's actually incredibly important for our students to understand Chinese SOEs. It's also incredibly important to understand that our typical distinction in the West that we've mapped onto the international about privately owned enterprises and state-owned enterprises actually doesn't, that black and white approach does not work really very well in China, where some of the studies of Chinese corporations suggest that actually the privately owned enterprises are less private than we might imagine, but actually many of the state-owned enterprises are less state than we might imagine. And so instead of it being black and white, there are various shades of grey, but either our students or we ourselves don't know that, or we don't know how to match that into our international system. So this, I guess, takes me to your point, and I'm really not sure what to do with this, Lucy, but when you sort of say, if we keep doing this very Western approach, yes, there's kind of increased hegemony there, but is it also hegemony that comes with an ignorance that makes us just increasingly irrelevant? Like,
if it doesn't make us increasingly irrelevant, it will make us increasingly unnecessary. Because at the bottom line, what I'm trying to say is that, and Andrew's written about it more than I have, is in the past, I don't know, decade or more, developing countries, and we'll put China in India, tiger countries, have needed and used US and UK educated lawyers. And I don't mean just internationally law educated lawyers, but people knowledgeable in our corporate law, in our tax law, in our business transactions, in our corporate social responsibility. They have needed us, and there's been a market for guidance for us, if you will, to help them, to be hired by them, co-counsel with them, whatever. And China and India as well are investing in having all those skills in their own lawyers, educated in our institutions in perhaps the old ways, but nonetheless the ways that are still being used in transactions and in international litigation. So this is a trend. I'm not saying we should stop it, but I am more aware, because of my foot on, in each area of the world, at how little my US colleagues, including in truly global or international firms, care about this, or want to notice it, or are willing to adjust to it.
Yeah. So Natalie, let me just come to you a bit, because you've obviously, you're not only in practice now, but you've been in practice in a variety of settings. So I think you've been a US clerk, you've been an international clerk, you've been an associate. So in those different settings, how have you seen education, both of your own and of others, playing a role in terms of approaches to international law?
So if you think about the different contexts in which I have practiced, so my US clerk I was a clerk to a judge on the Ninth Circuit Court of Appeals. So, the one that sort of spans the West Coast, sitting in Seattle. I then was an associate legal officer at the ICTY for 2 years, and then came to New York, where I've been at Debevoise ever since, so an associate and then a partner. The first question to ask is how many people actually talked about international law in those three settings. In my US clerkship, I was probably the only person who had taken a course in international law, much less wanted to incorporate it into my practice, much less wanted it to be the focus of my practice. My judge was very open to the discussions about it, but I was the only one who would actually sit down and say, sort of, if we are talking about sort of questions of asylum, then we have to consider the Convention Against Torture. We have to consider sort of the effect that has on US law and whether and how it could be taken into account. Most of my other conversations with my colleagues about that, while very well informed and very well intentioned, it took place entirely within the context and the universe of US law and sources. When I went to the tribunal, in some respects, it reminds me of sort of the difference between, if you think sort of, whether it's government counsel or in-house counsel and outside counsel. Frequently in the government role or in the in-house role, you will be either the only lawyer or the only international lawyer. So you're used to being the sole referent, the sole sort of person that people go to say, when they go to you at all, to say what is international law, and sort of whatever you say shall be the answer, and then it's up to them about whether or not they actually take it into account. Whereas going to the tribunal was like being in a firm where law is king. Like everybody talks about law, you focus it in the same way. So in many ways, that was the first key distinction, that you were in a group of people, and it was a community where you had a common point of reference. But much like your initial question to Carol, once you pushed beyond that initial point of reference, then you began to see differences in the way that that people spoke about sources and research. And again, at the ICTY, I was there in the 2000s, so a lot of sort of the early work had already been done, but we were still dealing in, when you got into some of the critical questions, sometimes with questions of first impression, and you frequently had to say, well, how do we answer the question? What do we look to in order to answer the question? And what we'd sometimes see is a difference between, for want of a better explanation, and I recognize that this is overly simplistic, a common law approach and a civil law approach. Lawyers who came from common law jurisdictions, regardless of where, actually, I should correct that. Lawyers who were trained in common law jurisdictions, so who had gone to school in common law jurisdictions, although they were international lawyers, and they would start with, sort of, is there any sort of text, is there a treaty? They would always end up with the case law. And if it was the case law of the institution, so much the better. But if not, then they would go to the case law of their home jurisdictions. They would go to the case law that they could read in the languages that they read. Lawyers from civil law jurisdictions would start with text, international lawyers, but they would tend then to go to doctrine, and doctrine as developed in the leading case books written by the publicists that they viewed as being authoritative.
The leading textbooks.
The leading textbooks, yeah. That they viewed as being authoritative.
Good catch.
See, there you go, I'm a common lawyer. That they viewed as being authoritative, and would then get to the point of citing case law, but would only really cite the case law of the institution. That I found fascinating to the extent that I thought about it, but frequently I didn't necessarily think about it. I was like, well, this is the way in which law is constructed, and frankly I thought that my way was better because it was richer. Query whether I would think the same thing now. In coming to affirm, the fascinating thing about the practice that we have, and it's a very similar practice at Freshfields and other firms that have sort of a broad-based international practice. The way in which you construct an argument, the sources you cite, the order in which you cite them, the emphasis that you place on them, will be informed by your own tradition, your own sort of practice background, but to be effective will always take into account, and again, this is coming back to the point, who your audience is. So, sort of a brief that we write for the ICJ will look very different from a brief that we write for the Supreme Court, will look pretty different from a memorial that we write for an ICSID panel.
Yeah. But also interesting, when you sort of say who is your audience, then it becomes key to know kind of what are the backgrounds of who's on the ICSID tribunals, and that all sort of has a role to play in all of this. 2 points to make on this, which is one of the things I realised when I was talking particularly to the French international lawyers was a very strong concern that internationalisation and increased internationalisation was actually common lawization, was the phrase. And I'd never had a haunting concern that internationalisation was civil lawization. I'd never even thought of the concept. So there's an interesting sort of asymmetry there about sensitivity, and I see somebody nodding, maybe somebody from a civil law background. The other thing I found when I was looking at sources from different countries, in terms of sources, it's not just about the case law. It's also about the General Assembly resolutions. So I had always understood General Assembly resolutions to be kind of not that important, not binding. That was what my case law had told me. And yet I found them being cited to at a strikingly higher rate, treaties as well, but particularly General Assembly resolutions, the two of them, at a strikingly higher rate in the Russian and the Chinese materials. And I wasn't sure how much of that was that these are all available in the native languages because of the translation process, and therefore they're easy to get, whereas if you go to the case law, you would normally have to do translations. I didn't know if it was that, or if there was also something else going on about relative power dynamics. But it really struck me because you got quite a different impression of international law in a variety of areas if you took seriously and elevated the General Assembly resolutions on the topic.
My instinct is that it's a combination of the ease of access, which we see, frankly, play out in lots of different ways in international law research. But it's also a focus on, where are the discussions happening about international law, and where do those different conceptions actually sort of arise? I would not be surprised if, for example, you actually had textbooks being written more in the periphery. Yeah. To the extent that people think about it consciously, the General Assembly resolutions are where you have the voice.
Right, that's what I thought too.
In discussing what, sort of, again, sort of what international law is, the way that different principles and fundamental norms can be reconciled. Yeah. It is interestingly, when we think about, so I mentioned, for example, sort of the homogenizing influence of practitioners in a particular field. So, sort of lots of investment arbitration lawyers, even if you come from different countries or you represent different sides, tend to use the same vernacular. The one place that I have been involved and seen in practice where you don't see that, regardless of how long people are there, is in the General Assembly. Because people are there specifically to represent their state's interests, and that gets embedded in and woven into the articulation of what the law should be.
Yeah, it's fascinating. I think that's actually really fascinating, right? And also interesting given changing geopolitical power. I'm going to open up for questions, so I can't actually see the microphones there, so please come over if you would like to sort of either share something from your background or have a question. But while people are doing that, are there questions within the panel? So, yeah.
For both of you who come from practice, one of the, part of this globalization is the spread of big law firms and the power of big law firms. And one of the things that seems to be new is who plays at international law. The strength of big law firms is forum shopping, finding the right forum for the right dispute. So to what extent has the field of international law become assimilated more into the world of big law firms?
Take that first.
No, please. I left.
Right. You have the longest sort of perspective and view. I think that it varies by field. The largest number of international law practitioners, again, if we define that broadly, in firms would be in international dispute resolution, and particularly in investment treaty arbitration, investor-state arbitration. You will find dominance of large law firms there. In terms of sort of the largest cases that will be brought will tend to be by the same relatively small number of firms, whether it is just the firm or in a co-counsel relationship. The effect that has is, at least my instinct, is that it will be less a direct effect on the law itself or the way that the law develops, but there will be effects. So there will be perhaps sort of multi-step effects, because as counsel you pick the arbitrators. And the arbitrators will then be the ones who write the awards. And as repeat players in both of those roles, you'd have to acknowledge that you have perhaps an outsized role on the development and the direction of the development of that body of law. Outside of international investment law, you will have big firms, but there are relatively few big firms who will play across the field. So who will be involved, for example, in boundary disputes or in international environmental law or cases before ICLOS. So for better or worse, you will be getting an even smaller number of firms to the extent that they play. In those fora, what you get outside of the big firms, you still get actually a concentration of counsel, but you get a concentration of counsel in the London-based chambers of barristers and the international law professors at Oxford and Cambridge. So in many ways, even though it won't be a big law firm phenomenon, you will still see a phenomenon of dominance and hegemony of particular views.
I would just say this. I always was more interested in practicing law than law firm economics or structures, but the first wave of the truly global law firms since the 80s, say, and Freshfields is one of them, it was for cross-border transactions where the clients demanded the best legal advice in many jurisdictions and national advice for deals, and our little practice is just a tail that wags the dog, actually, and there were truly integrated firms. The leading ones were lockstep, developing out of need, and the current spate of mega firms that are mergers of firms in the US and not tacking on, but adding competence around the world is to compete with the first generation of global law firms now that things are more global. And it's well, there are a lot of issues we could talk about with economics, but it's not driven by international law. It's driven by the need for a high quality of national law advice with some glue from the international lawyers, in capital I in the firm.
Jonathan Kutab. I'm a member of the bar in New York, in Israel, and in Palestine. And I've been fascinated by this discussion of trying to bring international law into the colleges and universities in the United States. But most of the conversation concentrated on the students, the JD and the LLM students. I wonder how much more useful it would be to concentrate a little bit on the professors, the teachers, to draw on competent, I have an interest in teaching, and to draw on competences from the periphery into US or Canadian or British law schools so that they can gain that richness and that wealth rather than just concentrate on the students.
So I think I'm probably the one that needs to answer that. So I think that teachers play a really important role in this. And I think that's partly when you have these core periphery dynamics, you also have a hierarchical relationship between the student and the teacher. And at least from what I observed is that there's much better penetration of ideas from the teacher to the student than from the student to the teacher. So if you have a very internationalized student body, but a very nationalized professoriate, then you have the ideas from that national being diffused to the international, but not the other way around, to a large extent. So one of the things I actually looked at were the educational backgrounds of the professors at the elite law schools in the 5 permanent members of the Security Council, and there are wild differences between them. So on the one hand, you have the Russian international lawyers at the elite schools. 98% of them did their first law degree in Russia, their second law degree in Russia, their third law degree in Russia. They published 98% of their international law articles in Russian language, in Russian journals. And it probably won't be a surprise to say that you have an almost entirely closed Russian international law universe, so that when you have discussions about Crimea, there is a rich discussion within the Russian language assumptions, within the Russian language sort of, and it just doesn't penetrate from the outside. You compare that over to a state like the United States, where majority, like around 70% to 80%, it depends sort of what level you're going at, most of the law professors have studied law just in America. They then go and work for a district court judge, sometimes then a US Supreme Court judge. Half of them go and work for the US State Department. They then come back and try and publish in US law journals to US journalist faculties. They're also quite distinctly nationalized, but there are exceptions, like NYU is an exception to this that has a much more internationalized group of professors. That is wildly different to what you have in the UK, for example, where about 70% of the elite international lawyers not only have law degrees from more than one state, but actually get their first law degree from outside, from outside the UK. And at least at this stage, your first law degree is still a relatively good proxy for your nationality. That's starting to change. And so what you actually get is a radically sort of more internationalized group of people in the UK teaching international law, but interestingly in a way that they kind of denationalise, right? So they end up focusing much more on international courts and tribunals and much more on that sort of horizontal international practice and much less, so they don't really teach you British public law, but frankly they don't really teach you the public law approaches of your other states too. And I have to say, look, I'm a classic example of this. I started as an Australian international law lawyer. I then went and studied in the US and UK and taught in the US and UK. And I can tell you basically nothing about Australia and international law. You know, I can tell you a lot about international courts and tribunals. I can tell you more about the American approach than I can about the Australian approach. And so there is, so when you do have internationalization, two things. The first is it still often stays very Western. So, and the UK is an example of that. It comes from the Commonwealth tradition and also from the European, but largely Western. But also these people themselves are quite extracted from their national environment. And this really struck home to me when actually somebody asked me to do a comparative foreign relations law course, and I at that stage didn't know what foreign relations law was. And so I said, nobody teaches that here, we don't even have a conception of it. And to give an example of that, I said, look, and I was teaching at the time, and I'd been in the UK, I think, for 7 years. I said I couldn't even tell you more than 2 judges that were on the UK House of Lords. And the US professor is trying to conceptualize the idea that he could have been teaching or practicing in the US as an international lawyer for 7 years and wouldn't even know who. And I was just like, you go and ask any of the international lawyers here, like, they won't do better than I have. Like, so you're very delocalized, I think, in quite an interesting way, and a very different way to what you have in America.
I think we have a couple of
questions.
Oh gosh, sorry.
Maybe
So
we,
what, maybe
we want
2.
to gather questions.
Yes, 2
Yeah.
questions.
Some comments.
So, Carlos Vasquez from Georgetown, and thank you for a very interesting discussion. It's been particularly interesting to me because right now I'm directing a program based in London, which it's based in London, but it's a consortium of law schools from around the world, each of which sends a professor and some students, and we study in a very transnational environment. And my experience there reinforces a number of the points that have been made, particularly about the diversity of ways in which international law is taught or not taught in various places around the world. And so as someone who has taught an international law course in that program, one of the big challenges is the different extents to which the students have or have not had the basic courses in international law. For example, the students from continental Europe all have had public international law, private international law. It's a required course. NUS is one of our partner schools, and the students I've had from NUS tend not to have taken international law of any sort. And from the United States, from Australia, it varies tremendously. It's not a required course. Some have taken it. But surprisingly, for students who have self-selected into a program such as this, a significant number have not had any exposure to it. So that reinforces, I think, one of the points. My question is about the extent to which programs such as this and LLM programs, which were discussed, are really about international law or instead about comparative law. Our program at Georgetown, we have various LLM programs, but the one that most of the non-US students take is called Common Law Studies. And so as the name indicated, it seems to be more focused on comparative law. And at the Center for Transnational Legal Studies in London, a lot of the courses are, I would consider, comparative. Our curriculum is dictated by the professors that the schools send to us, and many times they're not specialists in international law, they're specialists in a particular field and teach that field from the perspective of their country.
Great. We're going to collect a few questions, so.
Good morning, everyone. Is it on? Is it on?
Yes.
Yes. Thank you so much for having this conversation this morning. I teach at Tsinghua University in China, and we have 2 projects at Tsinghua. The first one is an LLM in international arbitration taught in English, entirely in English with foreign professors, teaching together with Chinese professors. We have Chinese students, but we also have foreign students. The second project we have is a compulsory common law project for undergraduate students. The culture at Tsinghua is to teach and prepare the students to go to the United States. It's been the culture of Tsinghua since it was founded in 1911. The law school reopened after being closed for 30 years, 20 years ago, and the goal is send our best students to the United States. So we're very proud of that. We want them to come back with degrees from the best universities and potentially publications in the United States. One of the requirements for our professors is to publish in SSCI journals. We call that the super stupid Chinese idea, which means that we have a compulsory list of, as you know, journals that we have to publish in, both foreign and Chinese professors. In terms of materials, I would say most of the books published in international law, international investment law, and WTO law are translated in Chinese. So our students read foreign books, foreign authors in Chinese. We have a hard time having them actually read in English the books. One of the caveats is that they never read the sources, they never read the cases. They just read the comments. Why do they take WTO law? We have also that problem. We have an over-representations of WTO law or international economic law in our university. we are to the point that we have to create basic principles of international law, or what is treaty law. We have to open those courses as non-compulsory to try to create a basic culture in international, which does not exist. Why is that? I think, first of all, when they come to the United States and pick those courses, it's because when they come back, they want to be hired by the big government administrations, MOFCOM and Ministry of Foreign Affairs. There is a big competition. They will drop a job at Sherman and Sterling to join MOFCOM, because in every embassy in the world, there is a group of representatives of MOFCOM. So they need to be trained, and they're selected on those topics, basically. Finally, as to the culture gap you've seen, what I think is, why do they, and maybe that's back to you, common law professors in the US, why do they use certain sources, like you said, the resolutions, the UN resolutions or so, just simply they don't know how to apply the law to the facts. They don't know how to draw a syllogism. They're lost when they read cases. They don't know what principle to draw from them, how to draw an analogy to existing. So back to you. How do you, what are the challenges that your students, your foreign students, are having when they're studying the law with you?
I actually think we're learning a lot from these questions, so I'm actually going to take the questions even if we have less time to respond at the end. So very short, final questions. Ed, did you have one too? But you go first. Okay, final question and then we'll... Okay,
I'm Cesar Coronel Ortega. I live and practice in Ecuador. I practice and I teach public international law there. And I've spent half my adult and professional life in the US and half in Ecuador. So this is very interesting and fascinating for me. First, just a quick comment, and I think it goes to what Lucy mentioned about the curriculum that she had put together with Professor Alvarez and how she was kind of ashamed to use it. Now, I would say, don't be ashamed to use it. I would, be careful about using only that. What I do in my course in public international law, in my courses in public international law in Ecuador, and I think I have a responsibility to use that kind of curriculum because I need to prepare my students to then be able to come to the US, to go to Europe, and to work at tribunals or at firms where they're going to be expected to have that kind of public international law training. So I almost approach the task as needing to teach the students 3 different languages. I teach them the US foreign relations approach to international law. I teach them the Latin American and local approach to international law, and we have a breadth of materials and we have a large tradition in international law, and it's different in Latin America. And then I teach them the sort of the 12 new approaches to international law, sort of like why both of those, of the first 2 might be wrong. But they need to know, and I tell them explicitly, these are 3 different languages. And you need to be conscious which language you're speaking when. And I think I would propose that as the way to do it in teaching international law in Latin America and in the developing world. The question I have, I guess for Anthea is, what did you run into in your research with respect to Latin America? I mean, did you look at it? And because really it hasn't come out. Latin America hasn't been mentioned in the panel, but I'm sure you've all worked there, and I'm sure you found something out about the region. I'd be very interested.
And one final one.
No,
Ed said he didn't.
Good. No.
Sorry.
I'm a final year law student. I'll be teaching US constitutional law in Germany as a junior, very junior lecturer. I have been doing work in my summers across India and the US, and I've had the opportunity to be deeply embedded in 2 very domestic settings. And I wonder I appreciate the project of looking at international law as very different approaches, but I wonder if we also have to start looking at the origins of international law in these different spaces differently. So we say new approaches of international law when we talk about third world approaches, but I think we have to understand, can we make more progress in understanding that these approaches are just not new approaches, but they each understand themselves in a much broader scenario? I'll be sure.
So we are being told that we're going to need to stop very soon. I'm just going to open up to the panel to see if there's anything people want to say, and we can continue the dialogue after that. So,
no, I'm quite happy to cede time to other people.
Okay.
Me too. I'll let it go.
Oh, come on.
Same here.
Okay.
Except to say I feel better about myself. Thank you very much.
It's 10:30 after all.
I do qualify. Yeah.
Okay.
My lectures.
Well, the great questions come up, and we'll talk afterwards about those questions, but thank you very much. And I actually found the backgrounds of what everybody was saying from the questions to be completely fascinating, so thank you very much.